Thank you, Madam Chair and members. I'm here to present AB 1766 with respect to juror privacy, and I want to make sure that we have the right context around the privacy, who we're protecting, and why. In this day and age of proliferate electronic devices, jurors who are being selected and going through the voir dire process are already in the middle of a very intimidating process and are a little unsure about being in court, and are asked to give their full name and are asked to then answer a lot of very specific and detailed questions that leave them feeling rather exposed. So what in talking with some of the DAs in California and with the witness who brought this to us that you'll hear from in a little bit, it seemed that it would be a better practice if through the voir dire process, the jurors were referred by the court without their full name, with an identification number, which I know it sounds a little harsh, and I don't necessarily disagree with that, or their first name and last initial, or with a title in their last name, not giving their full name. Now, of course, what the bill provides is that full name would be available to both parties. It would be available to the public if that's necessary. It's just in that conversation of voir dire, in that time when the juror is being asked those questions, their full name is not out there, so someone sitting in the audience isn't Googling and checking on them. That's the vulnerability that they are concerned about. This is not protecting the jurors against the defendants. This is not raising any other specter than the fact that a courtroom is a very public place. Jurors are brought into, they're asked to be there, and those of us who've served on jury duty know that when called, you will serve, and feeling, in a way, intimidated and particularly vulnerable. So we've settled on a fairly straightforward solution of just in court during the voir dire process or during the trial, restricting how the court refers to those jurors so that they don't quite feel as vulnerable. That's all this bill does, and I vote on our little bill here, 1766, and I do have witnesses in support.
Good afternoon, Madam Chairperson and Chair, members, committee members. My name is Dino Paraskevopoulos. I'm a Deputy District Attorney in San Diego County, and I want to thank Assemblyman Stone for bringing this bill. I also want to thank Bonnie Dumanis, the elected District Attorney in San Diego County, for co-sponsoring this bill. I've been a prosecutor since 1997 and handled multiple cases throughout the office and over 53 jury trials. This is a concern of jurors that I have witnessed personally, and in talking with colleagues and other DAs around the state, they observed this as well. I've also spoken with my neighbor, which you'll hear from soon, as to the impetus of this bill and the reason why it was drafted and the reason why I particularly took interest in it and drafted it. Every day, citizens across this state are called to serve as jurors in our criminal justice system, where they are subjected to a thorough and vigorous voir dire jury selection process. As Assemblyman Stone mentioned, they are asked to answer very personal questions after stating their full names, specifically their occupation, their spouse's occupation, their children, their ages of their children's employment, whether they've been on a jury before, whether they've experienced certain types of crimes or been the victim of crimes that they're actually being called in that particular case to sit on. And it's these prospective jurors that we want, that everyone wants, to be fair and impartial, and more importantly, to be candid during this process, specifically for the litigants. Both the prosecution, defense counsel, and defendant have a right to hear all of the information, and not just all of it, but candid information from these jurors. Our jury system depends on that active participation by the prospective jurors, requiring that they be truthful and candid and forthcoming about themselves and their lives. So this bill makes good public policy, makes good sense, because what we really want to do here is foster that dialogue with the jurors in the jury system. And I don't need to repeat what Assemblyman Stone mentioned. We're in a day and age where information on anyone is accessible within a matter of seconds at your fingertips on your smartphone. Jurors currently receive little to zero privacy protection during their jury service and during the voir dire process. As I mentioned earlier, it's good public policy to foster and increase candid juror participation and as well satisfaction You're going to hear from Ms. Julie Union, who had an experience and spoke to friends and neighbors about that experience. And what we don't want is the jurors to come out of jury duty disenfranchised and feeling threatened that their personal information is subject to abuse. This bill carefully and very, very narrowly crafts a solution to protecting prospective jurors' privacy while preserving the public openness of the voir dire process and allowing the court and counsel to address prospective jurors by a number, either their first name or their last name. What's important is that this bill allows all of the litigants, all of the parties, to have the actual names in writing. The parties get the names in writing before the selection process starts. Everyone has that, including the prosecution and the defense.
I'm ready to move the bill.
Thank you. Are there others in support?
Hello, greetings. Good afternoon, esteemed committee. My name is Julie Union, and I'm here to share my personal jury duty experience. I was so excited to serve on jury duty. This excitement turned to concern during the voir dire process. I was alarmed by how much very personal information is shared with the public and how your first and last names were used repeatedly. Are you married? What is your occupation? Have you or someone in your family been a victim of domestic violence? Have you or someone in your family been arrested or convicted? Are you in the armed forces? Are you in law enforcement? Sitting for hours, I started Googling some of the names and was shocked at how quickly and easily I could find information on my fellow prospective jurors. When one young woman, who reminded me of my oldest daughter, shared where she lived, that she lived alone, where she worked, and other personal information, I shuddered. I started to think, who is in this courtroom listening? Everybody is hearing all this very personal information about this girl and other people in the room. I believe there are three major concerns. One is personal safety. Smartphones give access at the touch of a finger. A person's home and work address is easy to find. In doing research for today, I found many cases of courtroom stalking, and I don't want to wait for a tragedy before we make a new law, such as Chelsea, Megan, or Jessica's law. The second concern is identity theft. Identity theft has become a serious problem. Sharing first and last names and detailed personal data is not safe, especially for the military personnel who have been encouraged to remove their first and last names off of social media. The third is jury duty apprehension. After this experience, I am concerned about serving again, and I'm not alone. Many of my friends feel the same way. We want to promote jury duty. We need to bring the courts up to the 21st century. A fair and impartial jury is the goal of the voir dire process. If citizens feel more comfortable disclosing personal information, both the prosecution and the defense will benefit. I request your support, and I vote on AB 1766.
Okay. Others in support?
Madam Chair, members, Dan Filizato on behalf of the California District Attorneys Association, co-sponsor of the bill, in strong support. And just for the committee's information, in Los Angeles County, we've been doing this for over 15 years without any issues. So we think this is a good bill.
Thank you. Others in support?
Good afternoon. Paige Hargis, President Safe Kids San Diego. As a concerned parent and citizen, I strongly support this bill.
Thank you. Others?
Chair and members, Jonathan Feldman with the California Police Chiefs Association in support.
Okay. If there are no others in support, are there speakers in opposition to the bill?
Madam Chair, members of the committee, Jim Ewert with the California Newspaper Publishers Association. The personal information that is being discussed here is used in the voir dire process for a reason, and that is to eliminate bias. And one of the best pieces of information to do just that is the identity of the person who is potentially going to make a decision about someone's life or their liberty. I can't think of anything more viable. If someone, a member of the public, is sitting in the jury or in the courtroom hearing the process, and they hear someone's name, they may be able to link that name to someone either on the defense or the prosecution or, some other means to let the court know that there is a potential for bias. The blanket use of secrecy also is a violation of the presumptive right of access that the United States Supreme Court established in a case called Press Enterprise versus Superior Court. And Senator Stone, this is a case that arose in your area and was taken to the Supreme Court twice. And in that case, the court looked at the voir dire process and how critical it was to the integrity of the justice system, and said that there may be reasons why the court needs to be closed or why information should not be publicly shared if there is an overriding interest to protect some other constitutional interest, such as the right to the defendant to have a fair trial, jurors' privacy interests even. And toward that end, it created a test to apply the overriding interest balancing that it discussed. And as part of that test, it looked at whether there were other alternatives that were available before you take the extreme measure of closing the courtroom. And from our perspective, just eliminating the names of the jurors does just that. It is the equivalent of closing the courtroom. Mr. Felizzato referred to the practice in LA County occurring for over 15 years, and yes, that is the case. And in fact, there were court decisions that challenged that practice that made it to the appellate court. And both of those cases challenged the county's use of their process, but they were brought by the defendants in cases where they alleged that they were receiving an unfair trial as a result of that practice. The public's interest was never, ever litigated in either of those matters. And quite frankly, the reason why the court found that those practices should be upheld was because counsel for the defense had the names of the jurors during the voir dire process. And that's how, that was a linchpin in the court's decision in that case. Here, we're looking at creating public policy for convenience. And you're asked to weigh convenience of jurors versus the overriding interest that comes to bear on the presumptive right of access. And I think there are other alternatives that are available to courts where private information may be disclosed in an open courtroom and someone has a cell phone that they could quickly Google information. And that is, the court can admonish jurors in the jury pool to simply put the cell phones away and turn them off. Then that can't be done. For all of these reasons, we urge a no vote on the bill. Thank you very much.
Thank you.
Thank you, Madam Chair and members, or should I say, the Senator from SD9. I have a lot of respect for the author of this bill, AB, or should I say AD 28. And I say this somewhat jokingly as I'm referencing numbers, but that's 20. I apologize. It's been a long day.
Yeah.
The point is that this is what we're going to be turning our court trials into. And for criminal defense attorneys, CACJ is opposed to this bill because for criminal defense attorneys, there's actually some utility in referencing potential jurors by full name. And current law allows some discretion in case-by-case basis not to do this. So there's really no need to change current law. But if we have a blanket rule, and this is something that we're sensitive to, maybe not everyone in the committee will be sensitive to this, but there are, in fact, reasons where jurors will walk into a courtroom and they will look at our clients and they will, because of their own views of the world, be scared of our clients. Perhaps they're dressed a certain, or they look a certain way, they have certain tattoos on them, and we struggle as defense attorneys, we struggle to try to get to a fair jury, an impartial jury, knowing that there are potential jurors who are going to walk in simply by looking at our clients and be afraid of them. To hear from the court, to be told, don't worry, we're not going to use your real name, is reinforcing that there's some reason to be concerned about using your name. Notwithstanding even a great description as to why, well, state legislature decided, doesn't matter. we use names, the defense attorneys use names, and I've talked to some in LA County who hate the practice, but I've talked to trial attorneys who say that they use that to make the defendant and the juror and everybody feel a little bit more comfortable about it. It's not just some guy who's perhaps shackled, perhaps not, looks a certain way on trial for a very sensitive case, to make jurors feel a little bit more comfortable and not looking at it as somebody less than human. It's just a practice that's really critical. And if we really care about impartial juries, then we need to do this. I have to mention that in misdemeanor cases, we know we're losing peremptory challenges. If there are jurors that feel so uncomfortable sitting up there in the box, they shouldn't be in the box. They shouldn't be jurors on the cases of our clients if they're uncomfortable using their names in trial. But that's not a basis for a judge to disqualify them. And with fewer peremptory challenges in misdemeanor cases, we're not going to be able to get rid of those jurors. That in and of itself, it potentially means that we have an impartial juror sitting there right now, if they're afraid to use their own names. So maybe that's something that should be a disqualifying trigger in current law. There's a lot of other ways to try to fix this. A lot of folks don't like jury duty, we get it. But it is probably one of the best, greatest, most valuable elements of our judicial process. And when it works, and works well, we all win. We ensure the right person's convicted, and we ensure that it's been an impartial jury. This takes us in a direction where it's kind of like the video game, no
Thank
personal
you.
connection. I apologize. Let me close. There's just really no need. Current law allows enough discretion, and I don't want to have to call everybody by numbers or first name and no last initial. There's no reason for it.
Thank you. Okay. Are there questions? Are there others in opposition? Are there questions or comments from committee members? Or Assemblyman Stone, do you want to address any of the concerns raised by the opposition?
Well, I can. And first of all, the constitutional issues, although the cases cited were not really on point because those were about closing courtrooms. We're not closing courtrooms. We're just temporarily and only for the voir dire process, not for the trial, masking the names of the jurors from the rest of the courtroom, not from the attorneys, not from the press. So those names would be available if anybody wanted to go see, but just in that voir dire action. There have been some cases that are worried about anonymous juries. We're not creating an anonymous jury because, again, these names are in fact available. We're just making it a little bit more comfortable for the juror who's there. Now, with the defense counsel, I'm very sensitive to wanting to build that rapport. And again, through the voir dire process, we're limiting under this bill first name, last initial, a salutation, Mr., Ms., sort of as we, Senator, Assembly member, Mr., Ms., how we refer to each other here on the floor in the legislature. Those are very common, so they're not really intimidating, but it's not putting that information in that full courtroom during the voir dire process. We've really tried to limit this. In fact, we've limited it only to criminal trials where the practice does happen when there's gang-related or some very emotional issues that are brought in. It can be limited. We thought that if we made it a common practice, we take the stigma away from those cases where it does get used in order to protect the jurors from the defendant in that case or from outside gang activity. Let's just provide a blanket, respectful way of addressing jurors that doesn't, through just voir dire, that doesn't put all of their information out there and make them less comfortable.
Okay. Are there any other comments or questions?
Madam Chair, I believe I moved the bill.
You did move the bill.
And I asked for your aye votes.
Okay, thank you. Senator Leno, I would just note, one of our members is going to have to leave very shortly, so we have two more bills after this.
I will be quick, but I am somewhat divided on this. And do other states follow this practice? Can we learn anything from them?
That I don't know. They might, again, this is used currently in some of our larger counties for gang-related cases, so I'm sure there are other states that are using it in that instance. There probably aren't as many states as California that are as aware of the electronic environment we find ourselves in, and that's really the reason for this bill.
Right. And I don't know that this has any potential value, but just something that I reach for when I'm not quite certain how it's going to play out and what unintended consequences. If there were a desire to put a sunset on this, what could we determine over time? It's almost, I don't know.
And see how it goes? Yeah, that's a possibility. I mean, if that's something that the committee's interested in.
I'm also not, I want to be careful not to add expense to your bill. I imagine we'd want to have some reporting back so that we could know what we learned. I'm not sure if the committee chair,
The
we've
bill
done that
as
sometimes.
now would go directly to the floor.
Okay.
So it would.
And
go-
would that change it and send it to approach?
It would.
Well, if you were going to have a report,
If we did the report.
yeah.
And is
My
there a way?
preference would be not to.
Of course not.
But
And is there a way for us, without the requirement of the report that would send it to approach, be able to benefit from the sunset? So that when a future legislature reconsiders,
I think
the
so, because
sunset-
even without requiring the report, what a sunset does is it forces the conversation
right,
in whatever period of time afterwards. And as long as it doesn't key it fiscal,
yes,
then that
Well-
gets done. We do that in our committee from
Right.
time to time as well, in order to ensure that we do have that conversation after a number of years, enough time for the program to
Right.
work and be able to see what the DAs think, see what the trial attorneys
Right.
think, whether it turned out to be a big deal or
we
not.
would have everyone's reported experience, even if not in a written form to
Correct.
us. So,
Yeah,
Madam
we
Chair,
could ask that
since the
question.
author is not sounding all that oppositional to the concept, I'm going to throw that out there if we might
Okay, how about a
consider that.
5-year sunset?
That would be fine with me.
Okay,
I like that a lot, thank
as
you.
amended. Okay,
So we'll talk about that, whether committee will amend it or we'll deal with the floor, but we'll deal with the.
Senator Leno likes my motions only if they're amended.
okay, we will
That's
amend it out of this committee.
Okay, thank you.
Okay. All
right.
Happy to.
And thank you, Senator.
Thank you. No,
excuse me.
seriously, that is very helpful to
Okay.
many of us right now.
No, that's easy. Yeah,
Okay. Would you like to close?
I've said enough.
Please read the roll.
Hancock.
Aye.
Hancock, I. Anderson. Anderson, I. Glazer. Glazer, I. Leno. Leno, I. Liu. Liu, I. Monning. Monning, I. Stone. Stone, I.
That bill passes.
Thank you.
Thank you very much. Assemblymember Alejo, item 24. This should be quick. Anderson, are you okay? Yeah, support on both sides.
Thank you.
You need to-
Madam Chair and members, I have no witnesses on this bill. This bill just came to my attention after 2 young children, ages 3, Delilah Terra and her 6-year-old brother and their 9-year-old sister. They were tortured, 2 of them were murdered. And this had to do with a situation when the remaining parent, their mother was deceased because of a car accident. The remaining father was incarcerated for a long amount of time. And when he was incarcerated, he was put in the care of a person who had a past history of child abuse. There was no background check. So we try to, knowing the circumstances, and there's probably a lot of other children in similar circumstances, trying to find a way to better inform their parents of their options, a way for them to be able to do a background check on that person that they're entrusting to care for their children during the duration of their incarceration. That's what this bill is about. Respectfully ask for your aye vote.
Thank you. Are there speakers in support of the bill? Speakers in opposition to the bill? Seeing and hearing none, I think it's a very good bill. Senator Anderson had moved, Senator Leno vying with one another to move the bill. Would you like to close,
No.
frankly? Okay. Please read the roll.
Hancock.
Aye.
Hancock, I. Anderson. Anderson, I. Glazer. Glazer, I. Leno. Leno, I. Liu. Liu, I. Monning. Monning, I. Stone. Stone, I.
Thank you very much. Really
That bill
appreciate it.
is out. Thank you. Assemblymember Quirk, item 20. I believe this is our last bill. Oh, we have one more vote only, that's right. Okay, item 20.
Thank you, Chair and Senators. AB 2027 gives victims of human trafficking an opportunity to apply for a T visa to temporarily live and work in the United States. AB 2027 would increase public safety by encouraging these survivors to report the crimes they were unjustly subjected to. In October 2015, Assembly Public Safety held an informational hearing on human trafficking. The key takeaway for me was the lack of attention we paid to labor human trafficking victims. This is why AB 2027 allows the Department of Industrial Relations to certify the victim's application. Trafficking is an insult to human dignity and assault on freedom. I respectfully ask for your aye vote.
Thank you. Again, Senator Anderson? You have support?
Yes.
Okay, there is
I'm happy to
support on
move it.
both sides. So please be brief.
Very briefly, Chair and members, Jonathan Feldman, California Police Chiefs Association. You know, law enforcement relies on cooperation within our communities for support, for information, for intel. It's what legitimizes the authority, that ongoing relationship with the community. So as this bill allows those who have understandable concerns and wariness in approaching law enforcement, some assurance that when they come to us, they will be helped, they will be granted our support as we ask for theirs in apprehending the true bad guys. And for that reason, we do support this bill. Thank you, Assembly members.
Khalif Pasagai with the California Public Defenders Association. Strong support of this measure. We really think this will go far in stabilizing the status of these individuals in the United States and helping to bring to justice their captors and those individuals involved in human trafficking. We worked closely with the author to add some amendments to the bill. We believe it's very strong. It protects both sides with respect to the prosecution, litigation, finding the right person, prosecuting the right person, and protecting the victim. So therefore, we ask for your aye vote.
Thank you. Others in support?
Micah Doctoroff on behalf of the ACLU of California in support.
Kimberly Johnson on behalf of Attorney General Harris in strong support. Thank you.
Okay, others in support? Speakers in opposition to the bill?
Magna Carta, I'm in support. I'm Rachel Victim of Trafficking. I'm also a Mother's Prayer Ministries. I'm also a 3rd Elizabethan by birthright and Queen Elizabeth number 3. Thank you, House Windsor Harris.
Opposition.
Oh, opposition to the bill?
Make sure.
Yeah.
Good afternoon, Madam Chair. Corey Sozil on behalf of the California State Sheriff's Association. We agree that victim cooperation can be extremely valuable in criminal investigations. Our concern with the bill is the rebuttable presumption that effectively states that a victim is being cooperative unless they aren't being cooperative. We think this determination should be the sole province of law enforcement. For that reason, we're opposed.
Okay. So, the bill has been moved by Senator Leno. Would you like to close?
The bill specifically states that you must cooperate in order to get the T visa, and it must be certified. So I think that answers the concern the sheriffs have.
Thank you. The bill has been moved. There are no questions or comments from the committee. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Glazer. Aye. Glazer, aye. Leno. Aye. Leno, aye. Liu. Liu, aye. Monning. Aye. Monning, aye. Stone.
The bill has enough votes to pass.
Thank you, Senators.